Fact sheet for you. Case, Lubitz, plaintiff versus Wells, defendant. Possible verdicts. After hearing all the evidence in this case, we, the jury, find that one possible verdict is the plaintiff, Sylvie and Judy Lubitz, have proven their case and award $15,000 in compensatory damages and $45,000 in punitive damages to the Lubitz family. Second possible verdict. The defendant, the Wells family, has proven its case that they were not negligent in any way and do not award any compensatory or punitive damages to the Lubitz family. Third possible verdict. We, the jury, find that the plaintiff was partly responsible for causing her own injuries, but is still entitled to some damages. We therefore award a certain percentage of the $15,000 to the Lubitz family and a certain percentage of the $45,000 to the Lubitz family. Fourth possible verdict. We, the jury, award the Lubitz family a certain percentage of the $15,000 for compensatory damages, but have decided to award no punitive damages to the Lubitz family. Once again, we have how many jury members? 1, 2, 3, 4, 5, 6, 7, 8. 6 of you, that's 75%, have to agree to reach a verdict. Do you still have your pencils? Who would like to be a jury foreperson this time? Looks like it's you. Thank you once again. Retire to the jury deliberation room. We'll await your decision. 13 objections that they were trying to think about using. Objections to opinions, objections to hearsay. In the previous trial, there were a few examples of hearsay. What someone told someone, especially when the manager said, "I was told, although I didn't see the gulping of the beverage," that could have been objected to. You know, and they were prepared, except in the heat of the moment they forgot to do it. Both sides had an opportunity to do something with that. As time goes forward, they're no longer rookies, that's for sure. So the next thing is going to be, can you think about listening even more carefully, and can you think about actually critical thinking, the possibility of stopping the other attorneys from doing certain things that legally they should not have been able to do. I'm very thrilled by the effort that they put forth today on both sets of trials. And I hope you guys see the benefit of this kind of education, which is very difficult to come by in this difficult, economic crisis we're dealing with across the board in the United States. Does anyone have any questions? Do the attorneys and witnesses have any questions? When the jury comes back, we'll ask them what they thought was important. Usually that really is helpful to a team to find out what did they hang their hat on that they thought made a big difference in the trial. Yes?
So what in our testimony could they have objected to?
I have to review the trial transcript. I just can't, on the top of my head, I can't think of what it might have been, but I'm sure there was 1 or 2 things.
Can you object to the attorney? Like if they're crossing our side and they say something that's not true, that's not in the affidavit, can you object?
Absolutely, we went over that. It's called invention.
Oh, okay.
Remember? You could have objected to invention when you talked about no children are allowed to play on golf courses, which, on closing that could have been hammered away at too. And now we have Jimmy Wells Jr., who is one of the only people in the United States who is barred from public golf courses. But you're talking about a high-level response immediately, and that is, in a perfect world, that would be a perfect performance. But they did such a wonderful job. Okay. Once again, we have the moment of truth. Now, once again, I have to ask you a few preliminaries. Did everyone have an opportunity to discuss this case? Did people have an opportunity to change their opinions and ask questions that were designed to influence other people?
Yep.
Did anyone feel pressured in any way to come up with a verdict? Because sometimes that happens in juries. I would hate to have to sequester you for 3 or 4 days, but we wouldn't be that happy about that after the 3rd day. Although we do serve excellent food, you would kind of get on each other's nerves after a while. Did they reach a verdict in this matter?
Yes.
Now, was it a unanimous decision, or was it a verdict of 7-1 or 6-2?
It was 7-1.
Okay, very much like the previous case.
Yeah.
What do you find?
So
first of all, before that, I'd like to have the plaintiff witness stand.
Both witnesses
Both witnesses. And the defense witness stand. Proceed.
Okay, so in the 7-1 decision, we, the jury, find the defendant, the Wells family, has proven its case that they were not negligent in any way and do not award any compensatory or punitive damages to the Lubitz family.
Okay. Now this, thank you. You take this in. This was a real case. It was heard in Darien, Connecticut years ago. This was a case from 1955, I believe. You can check it on the computer, look it up. And it was a classic case of negligence because the issue of trespass came to play. What didn't happen in this courtroom trial is there wasn't a question brought up by either side about how old you have to be to understand the trespass statutes. One side could have made a big deal about that. You know, I remember as a child not knowing where the property line was. That was a real mystical thing. It was an invisible line somewhere between homes, and no parent could tell me where it was. What they usually do is plant a shrub to demarcate the line. But it was always, you know, I remember as a child putting my foot on the property, saying, I'm on your property now. No, I'm not. I'm on your property now. Little kids things. So is it reasonable that Judy Lubitz could have even thought about trespass statutes? You know, that's a question you have to resolve yourself in your mind. How logical is that? Ringing the doorbell? Well, let's find out. What did you find was important in this case? There's a lot of testimony you heard. I'm sure you accepted some things, rejected others, and prioritized what was the most important thing. And what did you find? Anyone can answer for you, or you can answer for your.
Okay, so we found the whole, I know there was a lot of testimony about who can go to a golf course at what age, and, you know, why don't your parents allow that stuff. We found that to be sort of irrelevant because we found that what you do in your property within limits is your business. So Sweden Golf Course, we didn't find particularly, the Sweden Golf Club wasn't like really dangerous, and even if we could have gone to a golf course, it didn't matter. So we found that Sweden, the golf club, wasn't anything particularly bad, and so that wasn't a big like voting issue for us as a jury.
You would draw the line at practicing archery, though, would you?
Yeah, but we
what if I put a big target up right at the property line and started going from 60 feet away and hoping I hit the target?
That's all within limits.
You have an issue with that, though?
Yeah.
Okay.
So we found this within those like reasonable constraints. And the big issue was that whether or not the boy hit the golf club, hit the girl intentionally. And it just became a big like, you know, he said this and she says this. And at the end of the day, the real like nailing testimony, I guess, was when the mom said her windows were open and she could hear the club hitting the girl, but she couldn't really hear anything speaking. And since, I mean, even though this wasn't a criminal trial, we still kind of assumed that innocent until proven guilty. And
that's the same whether it's civil or criminal.
And so we assumed that the boy really didn't intend any harm. And since the mother's testimony kind of bolstered that by saying she didn't really hear her daughter say anything to the boy, we assumed it was an accident. And since she was on his property and he didn't know, we felt that it was the girl's fault.
Now, in law, there's a difference between intentional actions, reckless actions, and negligent actions. For example, in the case involving the late Michael Jackson, the doctor was found guilty of criminal negligent homicide. That's the lowest level of responsibility in criminal law. It carries a 4-year maximum penalty, which he received. Reckless acts are acts where you just don't care what you do. And I can easily see you didn't see this as a reckless act. And certainly not intentional. The plaintiff wasn't claiming in any way it was intentional. This was whether it was negligent. It was, oops, I can't believe I hit her. But you made the decision that the defense prevailed in this matter. I'd like to thank the members of the high school for coming in. I know it's a Sunday. I know it's time you could have been doing other things and watching some sports and other things. It really matters to have people that are doing trials actually have a jury come back and render a decision. It really helps them a lot understand what the process is, instead of the judge, as a bench trial, simply rendering a judgment.